described could be laid out as a he said, she said type of scenario, depending on the company and the culture where you work. So how will legislation like what we're going to see today in Ontario change that?
Right. With the new legislation, which goes into effect today, it's addressing workplace violence, domestic violence, and workplace harassment. So if you look at workplace harassment, it is subjective, and so the legislation identifies it as any vexatious comments or behaviors that are known to be unwelcomed on any part. So a reasonable person, how would you receive this type of behavior? So it's the responsibility of the employee to let the individual know that that particular type of behavior or those comments are unwelcome. At that point, the individual who is harassing the targeted person his or her behavior. And so with this legislation, it is subjective, but bottom line is the goal is to create a healthy, positive, respectful workplace for all employees.
Lisa, thanks for coming on today, sharing your personal experience and explaining for us a little bit more about what this law now means for employees here in Ontario.
For employees, what this law means is that employees can now go outside of the organization if they feel that their complaints, their concerns have not been addressed properly, so they can contact the Ministry of Labor, and the Ministry of Labor can come in and do some type of investigation and to make sure that the employer is in compliance with the
workers. Oh, I think that statistic proves my point, that if 59% of the people surveyed are saying they've been victim to workplace bullying, then what we're really talking about is a lack of civility. Even some of the language we see in the statute which talks about undermining work performance. All of us at some point in time have felt that a coworker or supervisor is undermining us. The solution for this, I think, is not more legislation and more lawsuits. The solution is for employers to continue to work through their codes of conduct, through their performance standards, to make certain that the workplace is a productive one.
But who makes sure that happens? I know you said that the smart employer doesn't want to have these kinds of situations, but are we going to count on all employers being so smart?
Well, I think not immediately. But I do think, particularly now, when productivity is such a tremendous issue in a bad economy, that employers are consistently striving to make their employees.
Yourself, have you had any luck talking with your U.S. Congressman?
No, I haven't. I have contact.
I always have people say, you know, they say, well, I write a letter, I give them a call, and they don't answer me, which I can understand that. If you can sit down, and it may not be the congressman, it may be a staffer, if they've got district offices, if you need to sit down across the desk face to face with them, like you have, to show them something there so they can actually be confronted with that. It carries a lot more weight. So
yes,
you might try.
Well, generally what I do is I will do a follow-up visit. I will present them an affidavit that I have written myself, and then I would send them a form letter or something like a cover letter on which they can then respond to a date of which we can meet. So the cover letter is basically to set up a meeting with them in regards to my situation.
For for a number of years, my friends and my coworkers all know it, and it surely has not been an impediment in me progressing.
Luc Cassivi certainly didn't talk about his sexual orientation when he joined the Canadian Navy in 1983. Now the highest-ranking sailor aboard HMCS Ville de Québec, Commander Cassivi is no longer shy about who he is.
The rules have changed and the culture adjusted. Like any culture, it takes a little while, but at the end of the day, most recognize that it's like the gender integration. If you're competent, it's not an issue.
Since the federal court ruled on October 27, 1992 that barring homosexuals from military service violates the Charter of Rights and Freedoms, more and more openly gay men and women have joined the ranks of Canada's Army, Air Force and Navy.
I'd say it's been a positive experience overall, and it's I've never reconsidered my commitment to the forces and serving as a consequence of sexual orientation ever since.
In the last 17 years, many have risen to the top in their respective fields, an otherwise impossible feat under the oppressive rules that once barred the promotion of enlisted individuals who'd been outed. Toby Cohen.
Mr. Speaker, today the House of Commons Standing Committee on Justice and Human Rights, of which I am a member, will begin a very important study into Section 13 of the Canadian Human Rights Act. This section prohibits electronic communication that is, quote, likely to expose a person or persons to hatred or contempt by reason of the fact that the person or persons are identifiable on the basis of a prohibited ground of discrimination, unquote. I'm very concerned about this particular section of the Act, Mr. Speaker. Any legislation which limits the ability to speak freely without fear of government reprisal is inappropriate in my view. While it's important to protect Canadians from discrimination, there are already provisions in the Criminal Code to provide recourse in such matters. In my view, this section of the legislation needlessly limits freedom of speech. As Voltaire famously said, I may disapprove of what you say, but I will defend to the death your right to say it. I look forward to a thorough and comprehensive study of this legislation at the Justice Committee, leading to a conclusion which protects Canadians from discrimination without compromising freedom of speech. Thank you, Mr. Speaker.
Mr. Speaker, on April 17, 1982, after years of lengthy debate and strenuous negotiation, our country adopted a charter that would bring transcendent change to Canadian life. The Charter of Rights and Freedoms enjoys a very high level of support in Canada today. Canadians do not only agree with their charter, they cherish the protections it offers, and for good reason. They are morally sound, they are necessary, and they are a reflection of who we are as a people. The citizens of every country in the world hold their own constitution in high esteem. They are documents or traditions or customs embedded in history and tradition. Even every good conservative Republican wraps himself or herself in the American Constitution. It allowed William F. Buckley to express himself and for Sarah Palin to defend things like gun control or not. Only in Canada do we hear politicians criticizing the constitutional documents that have founded a country and made it flourish. 30 years ago, Mr. Speaker, we had an uneasy relationship with our constitutional past because Canada was in the process of superseding colonial links and affirming its own identity. It was time more than ever to part with some of our past links and bring back our Constitution, bring it to our own country. We wanted to demonstrate to ourselves and to others that we had grown up and that we were a strong country. We wanted to assert our convictions, our principles, everything that distinguishes us as Canadians, and we wanted to declare those principles to the world. We Canadians appreciate the Charter because of its protections and the rights that it provides, but Canadians also cherish the Charter because it is a reflection of who we are as a people. The Charter of Rights, Mr. Speaker, embodies the character of the Canadian people. The Charter inspires us and appeals to the best of us as Canadians.
Three charging sections within the Criminal Code that deal specifically with hate literature and hate propaganda. The first is Section 318, subsection 1, and it basically says, it's generally referred to as advocating genocide, and it states everyone who advocates or promotes genocide is guilty of an indictable offense and is liable to a term of imprisonment not exceeding 5 years. This section then goes on to define genocide as any of the following acts committed with intent to destroy in whole or in part any identifiable group, namely by killing members of the group or by deliberately inflicting on the group conditions of life calculated to bring about its physical destruction. The next section is Section 319, subsection 1, and it's basically called public incitement of hatred. And it states everyone who, by communicating statements in any public place, incites hatred against any identifiable group where such incitement is likely to lead to a breach of the peace is guilty of, and then it talks about the penalties. Section 319, subsection 2 is generally referred to as willful promotion of hatred. And it states everyone who, by communicating statements other than in private conversation, willfully promotes hatred against any identifiable group is guilty of, and then it talks about the penalties. It's important to, when we're discussing this, and I often bring this up because it's a pet peeve of mine, the Parliament, when they wrote these sections in 6970, went on to define identifiable group. in other words, the protected groups under these legislation. And they defined an identifiable group as race, religion, color, and ethnic origin. 4 categories, and very narrow categories. And that's the law as it sits right now. There is another section, Section 320, which is not a charging section. It basically allows the police to go to a justice, get a warrant, and enter a premise to seize hate literature or hate propaganda for destruction. There's no charges under this section. It simply allows the police, under the authority of the court, to enter a premise, seize material, and have it destroyed.
On December 10, 2009, the Ontario government passed Bill 168, which amended the Occupational Health and Safety Act to address the issues of workplace harassment and violence. As an employer in Ontario, you have a legislated obligation to provide a safe and healthy workplace for your employees. That obligation now clearly includes freedom from harassment and violence. The first step towards avoiding the potentially costly complications of a harassment complaint is the development of a well-thought-out set of policies and detailed procedures that will clearly communicate how you will deal with harassment in your workplace. A thorough harassment policy should include a strong statement of your commitment to providing a workplace free of harassment and violence, a clear definition of what constitutes harassment, the procedure for your employees to report an incident of harassment or violence, and the detailed procedures to be followed in response to a harassment or violence complaint. It should also include a statement related to the disciplinary consequences of a breach of this policy and a statement regarding the confidentiality of the process. Harassment and violence in the workplace, when not dealt with quickly, consistently, and completely, can put you into a very expensive litigation process.
My situation in which I have become a victim of a crime which violates California Senate Bill 362. SB 362 was authored by State Senator Joe Simitian in 2007 and signed into law by then Governor Arnold Schwarzenegger. California Senate Bill 362 makes it illegal to transplant any subdermal electronic device in any human being in the state of California without consent. There have been several other states throughout the United States which have adopted similar bills. In addition to violating California Senate Bill 362, this is also a violation of FISA regulations. FISA stands for Foreign Intelligence Surveillance Act. Under FISA, it is illegal to implant any American citizen on United States soil without written consent. Violation of this regulation places this as a crime of domestic terrorism. This was adopted by our federal government. I have lived with this secret since 2009 when this was done to me. I kept quiet until I could come up with objective evidence to prove that this was done. After getting an MRI scan, a CT scan, and a high digital panoramic x-ray done of my temporomandibular joints and areas of my inner ear, we were able to see what appears to be a possible foreign body. I wanted to rule out the possibility to this foreign body being pixelation, which is denying digital images, an aberrant abnormality, anatomically specific to me, and matrixing, a phenomenon where the human brain compiles images of what was known in the past.